Welcome to Lattes and Lattes, the podcast where we blend the world of law and business with a warm cup of information and common sense. I'm your host, Sidney Wheelan, attorney, real estate investor, and business owner. Each week, we'll be your go-to source for legal insights, business advice, and so much more. Whether you're a seasoned professional, an ambitious entrepreneur, or simply someone seeking guidance, we'll have you covered. From navigating the legal landscape to empowering you with valuable business strategies, we'll explore the legal side of life and enjoy a virtual latte along the way. So, grab your favorite latte, get comfortable, and let's dive in to Lattes and Lattes. Welcome back to Lattes and Lattes, the podcast where we make the legal side of life practical, relatable, and, dare I say, even a little enjoyable. I'm your host, Sidney Wheelan, founder of the Wheelan Law Firm, now serving North Central Missouri families in 2 convenient locations in both Moberly and Carrollton. Today, we're talking about one of the most important, but often overlooked, parts of estate planning, and that is funding your revocable trust. Creating a trust is a powerful step to protect your family, but the trust only works if you actually move your assets into it. Think of your trust like an empty basket. You have to place your assets inside for it to hold and protect them. That process is called funding the trust. Let's start with real estate. For many families, their home or their farmland is their largest asset. To transfer real estate into your trust, a new deed must be prepared that changes ownership from you as an individual to you as trustee of your trust. This ensures that if something happens to you, your property can pass smoothly under the terms of your trust without probate. Here at the Wheelan Law Firm, we take care of this for you. We create the deeds required to transfer your real estate from your name to you as trustee of your trust, and we have those deeds recorded. Next, let's talk about business ownership. If you own an LLC or shares in a small business, those interests should also be assigned to your trust. This usually involves preparing an assignment of interest from you as the business owner to you as the trustee of your trust. And in some cases, it also means updating the LLC's operating agreement or business records. Again, at the Wheelan Law Firm, we take care of this for you. The goal is to make sure your trust owns your business interests so that your succession plan is clear and enforceable. So, you might ask, what about vehicles and bank accounts? These assets can also be titled in the name of your trust. Some states have rules or limits about transferring vehicles, so always check with your attorney before making changes. For bank accounts, most banks will allow you to retitle the account directly into the name of your trust. Alternatively, some people choose to keep accounts in their own name, but add the trust as a payable on death beneficiary. Remember, your trust is a private document, and you don't have to share copies of your trust with anyone, including the bank. At the Wheelan Law Firm, we'll create a certificate of trust that contains all of the information the banks or license bureau will need, such as the name of the trust, the date, and the trustee information. You may provide the certification of trust to the bank, knowing that your trust information, including the trust assets and the distribution scheme, stay private and secure. So, what about the assets that don't have a title? This includes household goods, jewelry, farm equipment, and collectibles. At the Wheelan Law Firm, we transfer these non-titled assets into your trust using an affidavit of transfer to ensure that all of your assets are transferred to your trust. Remember, the trust cannot protect assets that are not owned by the trust. One word of caution about retirement accounts. This is one asset that most folks should not place directly into the revocable trust. It's your IRA, your 401k, or other retirement accounts. If you retitle those accounts into the trust, you could lose valuable income tax benefits and trigger unintended tax consequences. Remember, most retirement accounts are funded with pre-tax dollars, allowing you to defer income taxes until money is withdrawn from the retirement account. If a qualified retirement account is retitled into the trust, those valuable tax benefits could be lost. Instead, the better practice is to keep those accounts in your name, but carefully review and update your beneficiary designations. You can name your spouse, children, or even your trust as a beneficiary upon death, depending on your overall estate planning strategy. This is one area where it's critical to work with an attorney and your financial advisor to make sure everything aligns. So, to recap, funding your trust is what gives it power. Move your real estate into it, assign your business interests, and properly title your vehicles and your bank accounts. But remember, leave your retirement accounts out of the trust and instead use beneficiary designations to coordinate with your estate plan. If you've already set up a revocable trust but haven't fully funded it, don't wait. An unfunded trust is like buying a safe and never putting your valuables inside. If you're not sure where to start, reach out to my office. We'll help you make sure your trust is funded properly so your family can avoid probate and enjoy the peace of mind you intended. Thanks for joining me on this episode of Lattes and Lattes. I'm Sidney Wheelan. Remember to listen to future episodes to learn more about some exciting new features and resources we are working on to help you connect, collaborate, and support each other in building wealth and legacy. I can't wait to tell you more, so stay tuned in the weeks ahead to learn how you can be a part of this new community. Until next time, my friends, grab your favorite latte, think about the people and assets you could protect by a properly funded trust, and keep on listening to Lattes and Lattes. Have a great week.
This podcast episode contains general information for discussion purposes only. Each case is different and must be judged on its own merits. Missouri rules generally prohibit lawyers from advertising that they specialize in particular areas of the law. This show should not be construed to suggest such specialization. Nothing on this show should be taken as legal advice for any individual case or situation. This information is not intended to create an attorney-client relationship, and the listening or viewing of this podcast does not constitute an attorney-client relationship. The choice of a lawyer is an important decision and should not be based solely upon advertisements.